as the various methods to go about analyzing data and evidence.
Did you apply the methods that you use in analyzing the department, the facts that they were provided with in today's case?
Yes, I did.
How did you begin your investigation, Ms. Lorien?
Well, I began by reviewing Greylock Strategies' 2014 audit and the recommendations that were made in this report. And from there, I was able to assess and determine whether or not Mickey Keenan's investigation fully complied with the guidelines outlined in this report.
Can you tell us how undercover operations played a role in today's case?
Well, high-priority white-collar crimes such as gambling, insider trading, extortion are known as consensual crimes. Now, all this means that there's a willing participant on both sides and no one is being forced into the crime. As bribery was suspected in this situation, Mickey Keenan was the undercover investigator assigned to the case to try and solve it.
Now, what were the specific guidelines that you analyzed?
There were 4 specific guidelines that I followed for this case. The first was whether or not the initiation of undercover operations was authorized, if written authorization had been approved by the appropriate level of management, if MSPD adequately supervised the ongoing of undercover operations, and whether or not the undercover employee received adequate training to properly execute his role.
Earlier, you mentioned Mickey Keenan's compliance with these guidelines.
Yes.
Can you tell us whether or not he complied with them?
Well, I reviewed Mickey Keenan's affidavit, and in this affidavit, it was the first time that I discovered that it was Mickey Keenan who first contacted Bancroft's executive assistant, Corey Hyde, and the 2 gentlemen set up a meeting, and it was during this meeting that Keenan recruited Hyde to help in his investigation. Now, the 2 gentlemen continued their work together up until about April 7th, which was the last meeting that took place between them.
Now, can you tell us what else you found in your analysis?
Other elements I found in my analysis were instances that also did not fully cooperate with the proper protocols outlined in my audit.
Would you mind elaborating on those specific instances?
Well, the first instance was, again, in Mickey Keenan's affidavit, and this was the meeting that took place between Bancroft, Hyde, and Mickey Keenan on April 13th of 2013. And during this meeting, on 2 occasions, Keenan slid a napkin across the table to Bancroft. Now, the first time, Bancroft ignored it. However, when Keenan repeated the gesture, at this point, Keenan looked to Bancroft and says, "It's always about the money." Now, the second instance I reviewed was one of the email correspondences that was sent from Mickey Keenan to Court Hyde.
If I were to show you a copy of that email in court, would you recognize it?
Yes.
Permission to approach opposing counsel has been previously marked as defense A. Let the record reflect I'm approaching the witness with the same. What did I just hand you?
This was one of the very first email correspondences between Mickey Keenan and Corey Hyde.
This is a fair and accurate copy.
Yes, it does appear to be so, yes.
Motion to enter defense A into evidence.
Any objections?
Your Honor, I object on the grounds of hearsay.
Respond.
Yes, you may.
Pursuant to Rule 703, an expert witness is allowed to testify to otherwise inadmissible evidence if it relates back to her conclusions. Now, being that she uses email in her conclusions, she's allowed to testify in court today.
Response?
Your Honor, while the expert is allowed to use this hearsay to determine her conclusions, she cannot be used as a conduit for hearsay and may not be allowed to read off the document or be allowed to let statements which otherwise may be hearsay into court. While she can testify on her conclusions, I must read my objection if she begins to testify hearsay.
Okay, you can respond.
I'm going to refer you case law of Richard v. Mississippi Barbecue. It states that an expert witness cannot be used as a conduit to hearsay, but they can testify to documents that they use in their analysis. As I just said, Ms. Lorien did use this in her analysis, meaning that she can testify to it and is not a conduit to hearsay.
Okay, I'm going,
Your Honor?
just one moment.
Sure thing.
You said, which case, sorry?
It's Richard v. Mississippi Barbecue, Your Honor.
It's on page 6, Your Honor.
Thank you. summarize, your argument is that, can you reiterate your argument just one more time?
Yes, Your Honor, it's both Rule 703
Mhm.
and the case law Richards v. Mississippi Barbecue. They both state that as long as an expert witness uses a document for her conclusions,
Mhm.
that she can testify to them in court.
Okay, and your argument is?
Your Honor, we haven't heard about these conclusions yet, and if she's used as a conduit for hearsay, as well as regarding Richard v. Mississippi Barbecue,
Mhm.
this can only be used if the expert first relates it to some specialized knowledge on the expert's part, which is in the third line of the ruling,
Correct.
and then the expert can rely on otherwise inadmissible hearsay to form scientific conclusions. But, Your Honor, we haven't heard about these conclusions or if the conclusions are even there.
Yeah.
How about you lay a little bit, or ask a couple more questions, just to lay a little bit more of a foundation, and then I'll rule, so just stand, stay standing.
Yes, Your Honor.
Can you please tell us again how this email relates to your conclusion?
This email specifically relates to the recommendations that I made in my 2014 audit and how they violated proper undercover protocol, and that is explicitly stated in this email.
Are there any affidavits in which this email was mentioned that you analyzed?
Yes, there was also mentioned in the meeting between Corey Hyde, Mickey Keenan, and Bancroft, where the same terminology is used, yes.
All right.
I'm gonna make a ruling, I'm gonna overrule your objection.
Yes, Your Honor.
Thank you.
Commissioner Defendant,
Yes, thank you.
what does this email say, Ms. Lori?
As I was explaining, that this was one of the very first corresponding emails between Mickey Keenan and Hyde. And in this email, Keenan clearly writes to Hyde that at some point Avery should do something to sweeten the pot in order to receive his bid on the new casino.
Did you find anything else worth noting in this email, Ms. Lori?
Just basically that Hyde really needed to stress to Bancroft that at some point Bancroft should sweeten the pot to Covington.
Were you able to come to any conclusions in today's case?
Yes, I was able to come to two conclusions in today's case.
Would you please tell us that first conclusion?
Well, my first conclusion was that Mickey Keenan there was no documentation regarding Mickey Keenan's proper training on undercover protocol, which in a case like this is absolutely necessary. If an undercover agent doesn't have the training, he cannot go about implementing the protocols in accordance to the recommendations in the audit.
Would you tell us that second conclusion that you just mentioned?
My second conclusion is that in relation to the lack of training presented by Mickey Keenan, the entire bribery scheme was thought up and implemented by Mickey Keenan.
No further questions. Permission to retrieve the document from the witness?
Yep,
Permission to the bench?
yep, thank you.
Yes, Your Honor.
Just one moment before you guys cross, okay?
Your Honor.
Okay, go ahead.
Ms. Lorian, you're compensated for appearing in court today, correct?
Yes, for travel and testimony.
You're receiving $10,000 in travel fees, correct?
That's correct.
And in total, you're receiving $30,000 for appearing in this courtroom today.
Yes, I'm a very busy person.
Now, I'm going to move on. Ms. Lorian, you reviewed 3 affidavits, is that correct?
2 affidavits and 1 report, yes.
And you also reviewed public records documents.
That is correct, provided to me by the Midland State Police Department.
And then you relied on your 2014 audit,
Correct.
which, just for clarification, it is 2015 currently, correct?
Yes, it is.
All right. Now, Ms. Lorian, despite only relying on 2 affidavits and 1 report, did you seek to interview Avery Bancroft?
No, I thought that between all the public documents I've received, the email correspondences, the affidavits and report,
But,
I had more than enough information to draw my conclusions.
so yes or no, did you interview Avery Bancroft?
No, I didn't think there was a need to.
Did you review Avery Bancroft's statement?
No, I did not.
Did you review Corey Hyde's statement?
Yes, I did.
Okay. Did you review Chase Covington's statement?
No, I did not.
Did you seek to interview Chase Covington?
No, as I've stated, I didn't think there was a need to. I had more than enough evidence in my opinion.
Did you seek to interview Devin Del Sesto? And I'm just gonna go out on a limb, you didn't seek to interview Ally Thomas, did you?
No.
Okay. So, did you attempt to interview Mickey Keenan?
No, as I said, I never attempted to interview, nor did I interview. I merely relied on the reports of the report of Pat Sikorsky and the affidavits of Mickey Keenan and Corey Hyde. So there was no interview conducted.
But you didn't feel necessary that, to talk with Mickey Keenan firsthand about Mickey Keenan's practices?
No, again, I had more than enough information in my opinion.
Now, all of your compliance standards were submitted in December 2014, correct?
Yes, that's correct.
And you're aware that the investigation started prior to the submission of your compliance standards?
It did, yes.
And yet you still assume that that the Midland State Police Department has reached the compliance standards at the time of currently?
Seeing as between the time that they started and when my document was submitted, yes, I did think at the time that they complied with the proper protocols.
But you didn't feel it was necessary to interview anybody at the police department regarding their adherence to your protocols?
Well, I actually did try to speak with Mr. Kimball, who's the chief operating staff, but however, my request was denied.
Did you try and interview anybody else in the police department following this?
No, like I said.
Objection asked and answered.
I'll move on.
Okay, thank you.
Regarding your qualifications, you've conducted numerous undercover operations, correct?
Hundreds, yes.
But you didn't speak firsthand with anybody participating in this undercover operation, is that correct?
In this one or in the
In
hundreds
this
I've done?
current one?
No, I did not speak to anyone directly.
No further questions, John.